Greetings, test takers. This is Dean Tinney coming to you from my studio here in fabulous Las Vegas. Whenever I do teach a class or do a tutoring or something like that, I like to use as a nudge to provide more free content on the YouTube channel. So this is a little carve out on securities registration. The state administrator, they all have a club called the North American Securities Administrator Association. And as you should recall, what you're getting tested on is called the template, the Uniform Securities Act. And the Uniform Securities Act is all about the state administrator wanting you to demonstrate you understand a broker-dealer, the registration of a broker-dealer, the registration of an agent of a broker-dealer, the registration of an investment advisory firm, the registration of an investment advisor representative. And today's little carve-out discussion, securities. You know, the Uniform Securities Act template says no person can lawfully offer or sell any security in the state unless the security is registered. So unless the security is registered or the security transaction is exempt, I think of exempt transactions as a verb, the way we're selling them, or the security is exempt. I think of that as a noun, a description of exempt securities. And then there's a carve out called federally covered. So let's get a whiteboard and let's just briefly go over this. There's a whiteboard, boom. So as we said, the state administrator, let me get my annotation tool going here. Exempt securities. Now, if it's an exempt issuer, the only kind of security they can issue or give birth to is an exempt security. So let's get us boom. We can't lawfully sell it unless it's registered. And if it's not registered, you know, the way I think of it is a state administrator says, did you sell this investment to one of my residents without registering the security? I say yes, but, you know, I better have some but or I'm going to be in trouble about it. And, you know, we can't put in one of those categories, then we're going to have to register the security. And as I said, you know, I think of the, you know, exempt security is kind of a laundry list, right, of things that are exempt securities. The big ones, you know, I won't get all of them here. Let's get a different color. You should definitely know. Now, remember, we're not talking about 33. We're talking about the Uniform Securities Act. But on both, the U.S. government is an exempt issuer. So I say to my state administrator, yeah, I did sell that security without registering, but it was a U.S. government security. And the U.S. government is an exempt issuer. So are their agencies. So, you know, doesn't need to be registered. Municipalities, that's a big one. I say, yes, it was a revenue or GO bond. And municipals are exempt. They don't need to be registered. For purposes of your exam, the provinces in Canada and the cities in Canada and the sovereign debt of Canada, no different than the U.S. Treasury. I'm coming to you from the state of Nevada, Clark County, Las Vegas. And in terms of registration under the Uniform Securities Act, Vancouver, British Columbia is no different than Las Vegas, Nevada. You know, the Canadian government. Now, when we say the Canadian government, it means exclusively government. So we're not talking about Molson's, which is a Canadian beer company. We're not talking about Hudson Bay, which is a department store chain, or Horton's, which is the Starbucks of Canada. We're talking about Canadian government securities. Now, Canada is the only one that we have that kind of an agreement with. So for other governments, for example, Mexico, we have diplomatic relations with. So foreign governments, just the national government, though, it's foreign national. What I mean by that is, you know, the analogy I just gave you, we're not talking here about Baja California. Baja California is a political subdivision of the Republic of Mexico. And unlike British Columbia, Canada, it's not an exempt issuer. Ensenada is a city in Baja California. That's not exempt. It's the sovereign debt, if you will, the sovereign debt. So we're talking about this laundry list of exempt securities, right? To carve out that we don't have to, you know, register with the state administrator. So I say, you know, I didn't register security. This was a Republic of Mexico Grand Centenario bond. The issuer is the Republic of Mexico. We have diplomatic relations. And so, no, I didn't register the security. Banks, savings institutions. I don't know if there's any more savings and loans. This thing comes from the 50s. And so one of the challenges is, the way people talk, the grammar is much different than it is nowadays, right? And trust companies. So we just go through the laundry list of, they say, Dean, did you register the security? And I say, no, I did not. Looks like I got a typo there. See if I can fix that. Some of these are less probable on your NASA exam, and some are more probable than others, right? Insurance companies. Again, it's not insurance companies get a free pass. It's that insurance companies have a different regular. Now we're talking about the insurance company as an issuer of securities. We're not talking about one of the products of an insurance company. So we're not talking about variable annuities, for example, right? We're not talking about the investments the insurance company owns. We're talking about an insurance company issuing its own securities. Remember, variable annuities are securities. They're mutual fund with an insurance wrapper. So we're not talking about that. Public utilities. Again, I don't think it's that they get a free pass. The way I think of it is they got a different regulator, like insurance companies answer to the Department of Insurance. Banks answer to the State Banking Commission if it's a state charter, to the Federal Reserve Board if it's a federal charter, FRB, or Comptroller Currency, FDIC if it's a national. And then public utilities, again, answer to the Public Utilities Commission when issuing, securities, not, the state administrator. And then our last one here in this basket, not all, this is not exhaustive, but these are the ones you should be able to deal with. Now, remember, charitable organizations, kind of a trick on your exam. Remember, no one and nothing is exempt from anti-fraud provisions under the Uniform Securities Act. So, if we catch you defrauding investors, you're going to be in trouble. Now, remember, there's another box here. Let's just make another box here of exempt securities. There was a carve out, the National Securities Market Improvement Act. The National Securities Market Improvement Act created a category of federally covered securities. And, federally covered investment advisors. The state administrators weren't a big fan of this because it took away some of their power. And those federally covered securities, again, I told you, I didn't worry about registering the security because it was listed on the New York Stock Exchange. It was listed on NASDAQ. It's a mutual fund compliant with the Investment Company Act of 1940. It's an exempt transaction under 33. It's a Reg D. Those are what we call federally covered securities. And again, the point then is I don't have to register those securities. Let me get a different color here. Right, so now exempt transactions is the way we're selling it, right? So as I said, let me just get a different color here. I think of the exempt securities as laundry list of federally covered. I think of this as a noun. What I mean by that is a description of the security. It's simply a laundry list Come on. And I think of this other one as a verb, right? Actually, verbs, how we're selling it. Let me get my boom. So again, remember the point here is the state administrator says, Dean, did you sell the security? Did you sell an unregistered security? I say yes, but. And I pick something from the left-hand side of the screen. I say it was an exempt issuer, and therefore they're exempt. The securities are exempt. It's a federally covered security, or the way I'm selling it. And so one of our exempt transactions, the way I sell it, is a pre-organization certificate. What I mean by pre-organization is I say I'll be your first subscriber and you haven't formed the business yet. For example, I'm having a business meeting Monday. We're thinking about doing something together. Either two of us or three of us. There is no, thing yet. There's no entity. There's no corporation or LLC or partnership yet. But I say, gentlemen, I think I want to participate. I'll be our first subscriber. Now, remember, there's a maximum of 10 subscribers, and I'm going to want some evidence. That's what a certificate is. A certificate is just physical evidence that I have the right to subscribe to whatever this entity becomes, whether it's an LLC, a corporation, whatever it happens to be. And here, there's a maximum of 10 subscribers. And no money paid in. I think it makes sense that we wouldn't pay money in anyways, because we haven't organized the structure to even accept the check. Even if I wrote a check for $500,000 or something, there'd be no way to cash it. Right? It looks like I misspelled subscribers. I always do that. I don't know why I always do that. Let's make sure we have no funds paid in here. Okay, so that's one, a pre-organization certificate. Let me underline that. Okay, so another exempt transaction. Be careful on your exam, by the way, because we have this idea of a private placement, and a private placement under the Uniform Securities Act is much different than a private placement under 33. So you got to kind of, separate in your brain housing group, whether you're being asked about the federal regulatory framework or the Uniform Securities Act framework. That's a little too big. And let's underline that too. Okay, so now this private placement, a little different. So, if I'm trying to find some more subscribers and you say, no, it doesn't really matter, it's a maximum of 10 subscribers. But if we're using this private placement as an exempt transaction, a verb, how we're selling it. And again, we're talking about the Uniform Securities Act. Here it's restricted to 10 offers. So I always joke, right? If I make an offer to you and you say no, I go, damn you, you just used up one of my offers. I'm joking, but yeah, not really, So that's restricted to 12 offers in a 12-month period. And remember, we're never talking about institutional investors. State administrator is always trying to protect retail investors in their state, Joe Six-Packs. So none of these rules apply. So just be careful about institutional investors because, institutional investors are capable of protecting their own assets, right? So we're always talking about state administrators are worried about protecting retail investors in their state. They are not worried about, protecting institutional investors. And to give you as a person who's in the business as a securities professional, to give you a incentive not to get people Joe Six-Packs involved, no commissions on sales to retail customers. So again, remember the big thing here is the state administrator says, did you sell a security in my state without registering it? I say yes, but, sometimes the legal term, let's put the legal term up here for what we're talking about. These are called, if you ever talk to an attorney, not just the Uniform Securities Act, but these are called safe harbors. I say to the attorney, is there any safe harbors? Is that a way to do what I want to do without getting in trouble? So here I don't get in trouble if the security is exempt or the way I sold it is exempt, then I'm going to be okay, right? We don't care about transactions with other BDs, right? Because again, BDs are capable of protecting broker-dealers. And we're talking about here protecting retail investors. We don't care about issuer transactions with their underwriters. There's all kinds of accounting that is appropriate for a privately held company, but not a public company. And so a lot of times the issuer and the underwriter will engage in reversing transactions before they go to public. The one I always think about is Snap. Snap had a portfolio of homes in Venice that they had their software teams on. And Morgan Stanley said, let's take those homes off the balance sheet, put the cash in there. That transaction between, Snap and Morgan Stanley is, something the state administrator is concerned with. Again, the underwriter is capable of protecting their own assets, and so is the issuer. And then remember this one, unsolicited. We probably want to make a, isolated. Now, remember this has nothing to do with whether you as an agent need to be registered. So, it'll be interesting to see TD Ameritrade's house requirements about unsolicited transactions allowed in their customer accounts is much more lenient than Schwab. And as they merge, it'll be interesting to see who wins out, because there's going to be some, if it's TD Ameritrade, if it's Schwab, well, then, they're going to be less likely. Unsolicited non-issuer transactions affected through a broker-dealer. So this is you buying a penny stock, for example, or some crazy security at TD Ameritrade on an unsolicited basis. I always warn you, RTFQ. Make sure you're reading the full question, because we're not asking about the broker-dealer need to be registered or does the agent need to be registered. The answer is yes, they do. We're asking about, do we need to register the security? And so the state administrator says, why did you not check and make sure the security is registered or not? I said, well, it doesn't matter if it's registered or not, because it's an exempt transaction. You know, wasn't the way the transaction was done is what makes it okay. And the way it was done is on an unsolicited basis. Now, again, assuming that we can't come up with one of these answers, you know, then we're going to have to register security. What's another one? So kind of running out of board space here, but fiduciary transactions. Now, we don't mean like fiduciaries and pension plans. We mean like officers of the court. You know, so officer of the court would be an executor of an estate, right? If I am the executor of a estate, I'm liquidating securities. I don't need to be worried about running afoul of this Uniform Securities Act and where those securities are registered, because that's an exempt transaction. I don't need to worry about this if I'm a trustee in bankruptcy. You know, if I'm a trustee in bankruptcy, you know, I've been appointed by the court and I'm liquidating securities, I don't need to worry about running afoul of the Uniform Securities Act. You know, these are all officers of the court. We're not talking about anything other than this. So, you know, we're not talking about a trustee in a trust account. We're talking about a trustee in bankruptcy. We're talking about an executor or executress of an estate. A sheriff in an asset forfeiture sale doesn't need to be worried about running afoul. And then remember, if that's not the case, then you're going to have to register the security, because again, we started the discussion by saying it's unlawful to offer any security in the state that isn't registered unless it's an exempt security or an exempt transaction. I did a little separate carve out on jurisdiction, but I remember now, if it's we don't come up with one of these things, then we're going to have to register it. Now, if we're going to be offering this on the federal level as well as the state level, we're going to use coordination. So coordination would be used where I'm going to be coordinating a federal registration with a state registration. This would be kind of like a traditional IPO, and whatever documents we file with the SEC, we're going to also file with the state administrator. And remember, the other way we can do it, and the most hardest one to do, is what we call qualification. And qualification would be for something that I can't coordinate. And so I asked the state administrator, I say, listen, what do I need to do to qualify to sell this security in your state? Now, then whatever he gives me, whatever that laundry list is, you know, then I'd say, aye, right? And whatever he asked me to do, that registration will be effective for 1 year. Right. Now, that's typically going to be, by the way, for Rule 147. So, you know, just be kind of careful here. There's some tricks. Yeah, I wouldn't say tricks, but, you know, Reg D doesn't have to be registered under 33 or the Uniform Securities Act. But an interstate offering, Rule 147, is a safe harbor under 33, but it's not a safe harbor under the Uniform Securities Act. What I mean by that is I'm still going to have to register that through qualification. All right. So I hope you found that little carve out helpful. Not exhaustive, but I'm trying to keep these carve outs at 15, 20 minutes. And so let me get rid of my chair board there. I'll just post this directly. You know, for longer lectures, I premiere them typically on Thursday. Not every Thursday is a premiere at 5:30 Vegas time. Tuesday, 5:30, we always do the live stream Q&A. But I'm just going to go ahead and put this up right now into the playlist for 63, 65, and 66. And remember, inch by inch, your NASA exam is ascension, yard by yard. Your NASA exam is hard. I'll see you for the next installment, whenever that happens to be.